Thank you. Please be seated. This is the time set for oral argument in Calhoun versus Smith. Let's begin with introductions of counsel for the appellant.
Good morning. My name is Lance Grover. With me today is Tim Bodie from my office. We are counsel for Darren Calhoun and Kristen Kierlin, who are both present behind us.
Thank you very much. Thank you.
Good morning, Your Honor. David McCarville on behalf of Barry Smith and Christy Smith and the Stardust Living Trust, and my clients are not present.
Okay. Well, thank you very much, and thank you, Mr. Calhoun, for joining us. Let me go through a few preliminaries. Each side will have 20 minutes, and if the appellant would like to reserve time for a rebuttal argument, when you go to the lectern, if you would let us know at the beginning of your remarks how much time you'd like to reserve, we will try and do our best to make sure you end up with that time for the rebuttal. Let me advise the parties and their counsel that we are recording the proceedings today, both audio and video, and you can go to our website and review them. And I think the video will also be uploaded in a few days to YouTube. Then let me advise the parties that we have reviewed carefully the briefs. We have reviewed the pertinent portions of the record in this matter, and we, the three of us, have met and discussed this case. So we're familiar with the issues you've raised, the arguments, and the basic facts. So with that, then last point, when you go to the lectern, because we are recording these proceedings, if you would please just restate your name. That way, if someone listens, they'll be able to identify the voice. So with that, let's go ahead and begin.
Good morning again. My name is Lance Broberg for the appellants Darren Calhoun and Kristen Kierlin. At this point, I would like to reserve 5 minutes for rebuttal, should that be appropriate. For 20 years, Darren Calhoun, Kristen Kierlin, their family, and their predecessors have lived on a property that had a house and a driveway that extended from 65th Street west along the northern border of the property and around to their backyard. That driveway is critical. That driveway is critical because there's a wash that flows through their yard and actually underneath their house, which is constructed with a hallway that serves as a bridge over the property. The driveway is the only way for a vehicle or really pedestrian traffic to make it from 65th Street, which itself is a dirt road in that portion of the valley, around to the back of the house. The driveway was throughout this 20-year period maintained. It was landscaped. It was visible. It was used. Items were stored on it. Construction was done on the property and the house using that driveway. Invitees stopped and visited the property using that driveway. It was a key feature of the property. This driveway was used for 20 years until approximately March 2014. What happened in March 2014? Well, as your honors know, Barry Smith and Christy Smith, the current owners of the lot to the north of my client's property, first noticed this lot to the north. The lot to the north was just a vacant, undisturbed piece of desert land, approximately an acre in size. This is a property that's located up near the Cave Creek area where there's a lot of desert landscape, large acreages. And by large acreages, I don't mean 30 or 50 or 100 acres. I mean 1 acre lots that have been developed, some of them, with homes, corrals, horses, those kinds of things. When Barry and Christy moved in, they intended to construct a house. They had a survey done of the property, and they noticed the property boundary wasn't exactly where it was believed for the past 20 years. You see, they noticed that the property boundary was approximately 20 to 30 feet south and actually cut across the driveway. So, as is often the case in these types of matters, they promptly put up a chain link fence blocking the driveway and precluding my clients from being able to access their barn, corrals, tractor, trailer, golf cart, really their backyard. 2.5 years later, here we are. The underlying case really was about two things: a prescriptive easement and adverse possession. Now, those are very, very similar things, and in the briefing as pointed out, they share three elements in common, and adverse possession has a fourth distinct element. I'll begin first with a prescriptive easement because that includes all of the first three elements. Prescriptive easement requires actual visible use of the real property or the disputed property for 10 or more years. It requires that that use began and continued as a claim of right, and it requires that the use be hostile. Now, the last two of these are usually the tricky parts. 10 years, frankly, we can all do the math on 10 years. We can look at a calendar and we can determine whether 10 years has passed or not. But the last two, whether it's a claim of right and whether it's hostile, are significant. Arizona has made it a little bit simpler for a person in my client's position, and that's what we refer to in the briefing as the Gusharowski presumption. As the Supreme Court noted in Gusharowski, as long as my clients, or as long as a party claiming prescriptive easement or adverse possession, make use of the property for 10 or more years openly, obviously, notoriously, and continuously, then there's a presumption that their use was hostile and was a claim of right. That shifts the burden, because the burden, that resolves the second and third elements of a prescriptive easement, and it shifts the burden then to the party who actually owns the underlying property to demonstrate that there was actually permissive use. The Gusharowski case is a case that's been around for a while, but unfortunately, approximately the year after Gusharowski was decided, there was another decision, LaRue. I want to touch upon LaRue briefly because, frankly, it's a bit of a cog in the wheel here. It's a bit of a speed bump that has surfaced in a number of different adverse possession type claims or prescriptive easement cases. LaRue was another Supreme Court decision. It included language in it, really a sentence that has been problematic and that has been relied upon by individuals who are opposing a requested easement by prescription or adverse possession. But look at LaRue if your honors choose to do so. What LaRue does is it decides that case based on the facts before that court. And what it ultimately holds is that the Gusharowski presumption remains good law in Arizona.
Mr. Broberg,
Certainly.
let me ask you a question about, it's more the record, I think, rather than the law, because I personally, and I think you make a strong case that Gusharowski, you pronounce it better than I do, applies and the presumption exists. I have taken a close look at Mr. Shepard's trial testimony because that is critical to the ability to attack, because your clients by themselves did not meet 10 years. And although perhaps the trial court could have gone a different way, basically, as part of his ruling, he determined that there was just simply, under the facts presented, a lack of continuous use by Mr. Shepard. And when I looked at Mr. Shepard's testimony, yes, I could see that he had gone and he had the composter, and he would make a couple of trips maybe every so often to use the composter. But when you got right down to it, the evidence that, or his testimony was really skimpy on the continuous use. And normally we defer to factual findings of a trial judge, and so that's what troubles me about this record. And
Sure.
how do we address that?
Certainly, a couple of things, and I understand the tacking concept that Your Honor is referring to. The trial testimony was really first. What Mr. Shepard testified to was undisputed, so there was no challenge to what use he claimed he made of the property, and how long or how continuous that use was. His testimony, and I understand that when asking a witness, was your use continuous, his testimony was literally, this was continuous use. This was something that he and his wife used throughout their ownership of the property from the time they constructed the house. Here are the items that he testified.
Wasn't he asked, though, to, and perhaps I'm interrupting where you're going, but to help unpack that, and what he testified about was something far less than day to day. It was perhaps twice a month, something like that, pretty infrequent.
Correct. That was his testimony, but it was twice a month, maybe less than that, over the entire time that they lived there. Now, his testimony was the driveway was there from the time the house was constructed. The existence of the driveway is an absolutely critical factor in this, because the existence of the driveway is the same thing as building a wall or building a structure on the property to the north.
What causes you to say that? Because a wall would preclude use as opposed to facilitate use.
Well, I get that a wall or a fence has a here's the boundary line feel to it. So a better analogy would be a structure. If there was an outhouse, if there was a barn, if there was an actual structure that was built across the property line. The reason the driveway is critical is because we're not talking about a path that went all the way through the lot. It didn't go from the west side all the way through to the east side. It was something that went from 65th Street through the lot down to my client's property. The property to the north was undeveloped desert landscape. There was nothing on it to suggest that anybody had built anything or constructed anything. And so the person who owned that property, if they ever visited the property, would have seen what was clearly in all the testimony, from the Smith's testimony to Mr. Shepard's testimony to my client's testimony to the neighbor's testimony, was this was obviously a driveway. In fact, we had those wonderful Google satellite images. The ones we used predominantly were 2003 and 2014. They showed what was clearly a driveway with ruts in it. So anybody who drove by that, if the owner of that property to the north looked at it, they would see somebody had constructed and used a driveway across their property. That's not something you can roll up. It's not something you can stow away. And it's distinctly distinct from, for example, if my clients had just walked through their property once a week, or if the Shepherds had just walked through their property, walking out in the desert, or if their kids went out there looking for bugs or other things. If that happened, then really you're dependent upon, did somebody see them? Were they out there enough that the owner of the lot would have actually seen somebody on their property and using their property? This is different. This is a driveway that was actually constructed, maintained, and remained on that lot for the entire time.
So your point then, I gather, is that mandated the trial court come to a different conclusion.
Correct. That's a key component of it.
Well, those are what you answered are two different
Right.
things. Did it mandate it, or was it a key component that should have led the court to that conclusion? Because those are very different things.
I think it mandates it.
Okay.
And
what is your best case for that proposition? Because I'm unaware of any.
I would say the Herren-Bassett case.
I'm sorry, say that again.
Herren-Bassett, and I am probably better with Gusharowski than Herren-Bassett. The Herren-Bassett case is really key because it's if memory serves, it's a 1996 case. And Herren-Bassett is almost the exact same thing that happened here. In that case, if your honors have read it, there's really two roads that reach a property. One of the roads, the road that was used predominantly, was this road that journeyed down into the Hassayampa riverbed. And it was used because it was shorter, faster, simpler for the property owner to actually make use of. The only time they didn't use it is if there was a flash flood or if the river rose too high that it actually obstructed the road. In that particular case, again, we're dealing with a road that's less visible because now it's down in a riverbed. The use of that road was in and of itself sufficient.
Tell me about the procedural background of that case, because I just don't recall.
Your Honor, and I'll have to double check. I believe I could be incorrect on this, but I believe it was after a trial. And I say that just because of the way the facts were ultimately developed, but I could be wrong on that. So this is just a guesstimate. But the Herren-Bassett case was interesting for another reason. The road was there. And the party asserting the adverse possession and the prescriptive easement had used it for an extended period of time. Then the person who actually owned the property across which the road went put up a fence. The Herren-Bassets came and tore the fence down, and the sheriff was called out. The sheriff said, rebuild the fence until you guys resolve this. And ultimately, whether it's a handshake deal, the case isn't clear on it, they reached some kind of a resolution where the owner of the property said, you know what, we'll take down the fence, we'll let you use it. And that continued for another 4 years until something happened, and the owner of the property put a car and then a pile of dirt on top of the car blocking the road again. So again, at that point, there might be an argument that, well, was there some kind of a permissive use after that point in time? The Herren-Bassett court said no. The Herren-Bassett court said that use of the road was sufficient.
On that, and I'll read the Herren-Bassett case. But I understood you to answer Judge Thumma's question by saying the mere existence of the driveway mandated a finding in your client's favor, as opposed to the use, and it sounds like Herren-Bassett was all about the use of the roadway.
There's two components to that. The existence of the driveway I think, mandates it if it's maintained and continues to exist. It's no different than having a structure built upon a property. In this case, we have not only the existence of the driveway, but the Shepherds testified that they used it. It was maintained in good condition.
Excuse me, and I'll go back and look. I don't think Mr. Shepard testified he maintained that he did any work on the driveway.
Well,
If you've got a
You're-
record site, point me to the place in the
he
record.
did not say that, for example, he went out and he trimmed the trees or anything
Right.
along those lines. But what we have is the testimony of when he sold the property to the Calhouns, that the road looked like it had been maintained in good condition. There were no weeds, that it was a workable driveway. It was not something that, for example, had been created 11 years earlier for the construction of the house, and then the desert had subsumed it in the 11 years since that time. It looked like a valid, operable driveway. And I would add that the composting bin, and the testimony I believe came from Sheila Derrick, was the composting bin was actually stored on that driveway at the end of the driveway and could be seen from 65th Street. So in this particular case, we have the existence of the road, which is effectively a structure that is built upon the property to the north. And then we have the use. Even if it's limited and it's not daily use, we have the use of the property. And we've cited a number of cases in the briefing talking about the significance of use. My favorite one is the Zuni tribe case. We won't go into that because I think that candidly is an anomaly and I don't want to use an extreme here. But there are other cases that talk about, for example, and I'll try and pull the name of the case momentarily for you. But there's one case that we cited that talked about, I think it's K versus Biggs, 13 Eras App 172. In that case, the individuals only used the property. They built a home on it. They put a fence and they had some apple trees along the boundary. I think it was about a 30-foot incorrect offset on where the fence was and where the property line was. And they only used the house 2 to 3 weeks a year. That's it. The rest of they were snowbirds. The rest of the time they were out of the state. They weren't living in or actively using or doing anything with the property, best anyone could tell. And the court said, all you have to do is determine whether or not the use was reasonable for that particular property and for that disputed land. Here, what the Shepherds testified to was reasonable use for a dirt driveway leading from 65th Street to the rear of their house. That's all that we were seeking in this particular case was the reasonable use of a dirt driveway that leads from 65th Street to the rear of the house that was otherwise unreachable, either on foot or by vehicle.
And by that, you're dealing with the prescriptive easement claim
Correct.
only, not the adverse possession claim, which is very different.
Well, the adverse possession is I don't think it's that very different. I think adverse
I
possession.
think there's a difference between being able to use something that someone else owns and getting a judgment saying you own that, even though someone else used to own it.
The only difference in the case authority is exclusivity. And so, for example, if that driveway had been used by other individuals in the neighborhood, you'd be limited to an easement because it's not exclusive. This goes only one place.
Can I ask as well, I did pull up Herrenbassick, and it seemed to me that the legal issue that this court addressed was whether the use was permissive or not.
Right.
I don't think there's any claim that the use here was permissive.
This being the Herrenbassick,
Yes.
the focus.
I mean, the facts are
correct.
similar, but the legal issue, it sounds like, is quite different than what
Well,
we asked to address.
I don't think it is because the focus, while that case concerned permissive use, this case we never did. The reason
Right.
Herrenbassick.
That's my point.
The reason Herrenbassick is important, though, is because it was the use, permissive or not. It was the use alone that was required. It wasn't
Well, to be
maintenance.
fair, I mean, Herrenbassick discussed and focused on a different legal issue, as Judge Thumma points out. And the decision, which I have here as well, just simply discusses in passing that the Herrenbassicks used the riverbed for the road. It doesn't really go into the level of the use because that was not the focus of the court's opinion. So we're just left with, yes, they used it, which kind of begs the question because we know the facts drive the law in this area. It's the facts of Mr. Shepard or the Shepard's use that is so critical here because there's no question your clients clearly used this road once they obtained ownership of the property. So
Well,
that's not, their use is not in question, it's Mr. Shepard's.
I would refer you to the K versus Biggs case, and I would also refer you to Spilsbury versus School District number 19. Those cases both concern the use. And again, the focus is not daily use. There is no objective criteria for what constitutes sufficient use.
Well, but that's the whole problem here, it seems to me, is that it depends, we have case after case that says this, the continuity of use is fact-driven. It depends on the circumstances. We know these circumstances. The trial judge is the finder of facts, and insofar as that's a factual determination, I might personally disagree with it. I might have made a different determination based on the facts, but under the rules that govern appellate courts, we normally defer to factual findings of a trial court.
Certainly, and I want to be cognizant of, I see that too clicking quickly. I'd refer you to those other cases. Again, the focus is not an objective number. It's not one time a week, one time a month, whatever it is. The focus is, did the Shepherds use the driveway as an ordinary, reasonable person would use that type of a driveway in that particular area? That's the question that the courts focus on. And in this particular case, the testimony was clear that the Shepherds did, in fact, use it. They use it to store and access their refuse containers, gardening materials, access the back door, which, by the way, is on the north side of the property. So the driveway gives access to the back door of that particular property. It's where neighbors came and accessed it. They used it to leave the property to go walking. And then obviously the composting bin was stored on the driveway, and they would go out to take things to the composting bin up to the front, sufficiently enough that neighbors in the neighborhood saw them hauling their wagons to and fro. At that point, I'd like to reserve my remaining time for any rebuttal.
Okay.
Thank you and good morning. David McCarville on behalf of the appellee. I'd like to pick up on the last conversation and start with the court's ruling here. He specifically stated that the Shepherds' use of the driveway did not fly the flag. He recited testimony that confirmed the Shepherds did not construct the driveway. It existed when they purchased the property. And subsequent to that time, the Shepherds used the driveway twice to access the side and backyards in connection with construction of their home, and two, occasionally or periodically, particularly to access composting bins and refuse containers stored on their own property. These occasional or periodic acts do not give sufficient notice to the true owner that the driveway was being held adversely, and the court cited to Gospel Echoes Chapel v. Wadsworth. And the testimony supports the court's ruling. Calhoun argues that the testimony was that the driveway was obvious, and you heard counsel argue that the existence of the driveway basically mandates a finding of adverse possession or prescriptive easement. That's not correct, and that's not what the case law says. Even if it is correct that the existence of the driveway was obvious, Shepard's use was not obvious. Shepard's own testimony supports this. He states that he did not maintain the driveway. He did not store anything on the driveway. He only occasionally used it to access the rear of his property. And the judge clarified at trial that the only extended use of the driveway was during the two instances of contractors working on the house. So the reliance upon Shepard's use to fly the flag is simply not there.
Counsel, let me ask you, appellants take exception, although we haven't yet focused on that in oral argument, with the fly the flag concept, arguing that applies only when permissive use becomes prescriptive or adverse. What's your response to that argument?
Well, if I understand the question correctly, I think that in this case, there was actually testimony that stated that prior owner, Mr. Shepard, had met with the prior owner of my client's property. And at no time was there a discussion about the driveway. Right. And there is another driveway that is actually used on a daily basis to access the Calhoun house. There's a big U driveway off 65th Street. So I don't think it was obvious to the prior owner of now the Smith's property that this driveway was an adverse possession, because it didn't clearly service what is now the Calhoun's property.
Let me see if I can clarify, because the question I have is somewhat different than that.
Okay.
The fly the flag, the argument is, hey, only time fly the flag concept applies, and the trial court, that was one of the grounds that the trial court relied on, was when the use starts as permissive and then becomes hostile or adverse. I don't think there's any suggestion that the use started as permissive in the sense that the prior landowner said, sure, use it. We have this robust discussion with Mr. Shepard about his ability to use it. The question then is, from a legal perspective, what's your response to that? Does fly the flag apply to, adverse possession and prescriptive easement claims across the board, or is it limited only when such a claim starts as a permissive claim and sort of morphs into an adverse claim?
Well, I think it's very dependent on the facts. And in this case, you have to look at the facts that this lot that my clients purchased was unoccupied. And so the prior owner did not fence it. And this is not uncommon in this area. And the case law, I think, supports this. You have to look at what is the context of the adverse possession? And in this particular case, there was an existing driveway servicing the Calhoun's property. This driveway was on my client's property, but did not serve an obvious purpose to provide access to Calhoun's property.
And if, to play that back, your position then, I rather gather, is the fly the flag concept applies across the board. It doesn't turn on whether the first use was permissive. Is that fair?
Well, I think in order for there to be adverse possession, they would have to show some exclusivity and some flying of the flag, whether it be a sign that says private property, whether it be a fence.
What's your best case for the proposition that fly the flag applies across the board?
Well, there are several. I mean, the case that the court relied upon was the case cited in their opinion, and that's Gospel Echoes Chapel v. Wadsworth. And in that case, the court cites to a number of other cases. So,
and Wadsworth did not start as a permissive use. Is that your recollection?
Wadsworth claimed that they had a use of a 3.2-foot strip of land, and in that case, there was never any attempt to exclude anyone from using disputed property until a fence was erected. So in that way, it's similar here. I think.
And I guess just so we're on the same page, when I'm talking about permissive, it is landowner A talking to landowner B saying, hey, do you mind if I do this on the property? Landowner B says, sure, not a problem.
Right. That's not the case here, obviously.
Right. I understand that.
Mm-hmm.
But is your recollection that that was the case in Wadsworth?
I don't believe that was the case in Wadsworth. I believe the case.
You quote part of Wadsworth, the portion of the opinion that says occasional or casual acts do not give sufficient notice to the true owner that the property is being held adversely. So that's the same as fly the flag, isn't it?
That is, and that actually is citing to England versus Ali Ong Hing, and that's correct. I mean, that's exactly what the court found here, which was the occasional or casual acts of Mr. Shepard did not give sufficient notice to the prior owner of the adverse possession. And in this case, you'll see that this is a situation where the prior owner was absentee, and there are cases that hold that in a situation where you have an open area of land, to allow a neighbor to access their property via your land may be a neighborly consent and implied permission. And that's what the England v. Ali Ong Hing case argues. Now, that deals with cattle grazing, but I think in this case it does apply from the standpoint that this is a very undeveloped area. This is not a rural setting. This is dirt roads, there are washes, there's ingress and egress all over the place, and it's very difficult to ascertain what is merely a path versus someone adversely possessing or claiming a prescriptive easement. And so in this case, and there was some testimony too regarding the fact that Mr. Shepard even admitted that it may have been implied permission from the prior owner allowing him to use that driveway. And at no time was there a discussion between Mr. Shepard and the Calhouns where he specifically told them, I am adversely possessing or acquiring by a prescriptive easement over this driveway. And so that's a separate issue of privity and tacking, where there clearly was no transfer of title, recorded title, to this area, but there was also no discussion about this particular easement being transferred with the sale of the property. And that the whole line of cases on tacking, you have to have some sort of discussion or some sort of privity. You can rely on an oral transfer, but that didn't take place here. And that was also clearly shown in Shepard's testimony. So in this case, the strongest argument we have is that the Shepard's use of the driveway did not fly the flag, and that there was no sufficient activity there that would have put anyone on notice of the adverse possession. It certainly wasn't exclusive, because you have testimony from the neighbor, Mrs. Derrick, that she walked that roadway every day. The facts of this case, I think, support the court's decision. The judge did visit the site, and he recalls that when we talked about doing closings. He had seen enough at that point, and he went out there and visited the site. He also recognized the driveway pre-existed. When Mr. Shepard testified, he confirmed that the driveway was there prior to his arrival. He only used it twice for access in and out. He did not give notice to the prior owner of his use. He didn't give notice to anyone by a posting of a sign or otherwise any kind of monument or any other notice. So there was possibly some implied permission, and he did not maintain the property. So he didn't install it, he didn't maintain it, and there certainly was no privity established because he didn't explain to the Calhouns that he was also occupying this driveway or using this driveway and claiming an adverse possession or a prescriptive easement. The area, too, I think it's important to recognize that from 65th Street, there's basically a triangle of vegetation. And so the driveway is obscured, and there's testimony that kind of helps support that. There's no signing or fencing around the driveway, and it was certainly not exclusive. So based on those facts, I think it would be extremely difficult for the court to have found that because of Shepard's use, that the Calhouns could tack onto that and claim adverse possession or prescriptive easement. Now, the Calhouns did construct a corral back there, and they did use that roadway to get back to the corral, but they didn't have the property for 10 years. So they have to rely upon tacking in this case in order to claim adverse possession or prescriptive easement. And the court found correctly that there's simply not enough evidence to support that. The Heron-Bassett case I would like to touch on briefly. Heron-Bassett is interesting in that there were two roadways to the home. The one that was used most often was the River Road. And in this case, you have two driveways, one that is used most often, which is the one that goes to their front door, and that is the nice U driveway that is maintained and is installed in front of the home. And the other driveway is this one that starts north of the property and is after a period of vegetation. It drives back on my client's property towards the back of the Calhoun's property. But it is not the most direct access to the Calhoun's property. So it's different than the Heron-Bassett case in that way. You also have a discussion about the LaRue case, which is in the Wadsworth case that the court cited. It states there, in a similar fact situation involving an easement by prescription, the Arizona Supreme Court stated, it is not sufficient that the claim of right exists only in the mind of the person claiming it. It must in some way be asserted in such manner that the owner may know of the claim. And that is citing to LaRue v. Koshich. And in this case, that's exactly what happened. If Mr. Shepard did have a claim of right, it existed only in his mind. He didn't explain that ownership either to the Calhouns or to the prior owner of the Smith property. He didn't put up a sign. He didn't use it in a continuous way that would have been similar to the River Road in the Heron-Bassett case. And again, the ultimate citation the court relied upon comes from England v. Aliong Hing, which is occasional or casual acts do not ordinarily give sufficient notice to the true owner that the property is being held adversely. And that is certainly the situation here. I think the court has rightfully ruled here. Obviously, the Zuni tribe case is another case that was mentioned. In that case, you had the Zuni tribe periodically, I think it was every 4 years, they would cross over another property as part of their ritual pilgrimage. And every 4 years they did that, and the court found correctly there that the Zuni tribe, because they had done this, even though it was infrequent, it was consistent, and it was always through a certain path, that because of that, they had acquired over time that prescriptive easement. And in that case, it's very much different than what happened here. The Zuni tribe was not trying to tack their use on to a prior use of the same roadway or pathway. They simply had been doing this for the longest time, and so they were able to perfect their interest. Counsel is correct. Shepard's testimony was undisputed as to a few things. Certainly, he testified that he did not install the property, he did not maintain the property, and his use was certainly infrequent. And because of that, there was no open, notorious, and adverse use that the Calhouns could have used to tack their use onto and to acquire, either by a prescriptive easement or adverse possession, the driveway that's in question in this case. If you have no questions for me, I believe I'm finished. Thank you.
Lance Broberg again for the appellant. I'll touch on 3 brief points. The Bunyard case is a case that talked about, and it's cited in the briefing, that talked about when there are significant gaps in ownership of property. In that particular case, there were significant years' worth of time in which there was no use of the particular roadway or the property that was in dispute. And what the court said is, ultimately, a condition what's shown to exist is presumed to continue to exist. And what the court said is, all that we're looking for is, all that is necessary is that the occupancy and use of the land would be that of which a normal owner of the land, taking into consideration the changing uses for which the property in general neighborhood may be put. So I would cite the Bunyard case and the Kay case for that proposition. 2, tacking. I'd cite you to the trial transcript at pages 56 through 58. It's actually included in the appellee's appendix at page 58. When Mr. Calhoun purchased the property, he walked the driveway with Mr. Shepard. They walked all the way back, and it talks about finding a steel post that had the title owner of the north property on it 20 to 30 feet above. They thought the driveway was part of the property that was being sold and purchased. Finally, I addressed the England versus Allion case in the briefing. That case is apples to airplanes relative to this. If you have any questions, I'm happy to answer.
Thank you very much. Well, thank you for your briefing, and thank you for your argument today. We will take this matter under advisement and issue a decision in due course. Thank you.